Today's Imprint Weekly podcast is brought to you by Accenture. Change is afoot in child welfare. Change that means agencies focus on results for children and keep far more of them safe at home with their own families. Accenture's child welfare team is leading the way in the effort to ensure technology does its part in that success story. Accenture offers cutting-edge case management tools that ensure agencies can see insights that drive decision-making and caseworkers have information they need at their fingertips. Together, these tools help agencies stay laser-focused, reinventing child welfare into a source of strength for families when they need it. For more information, visit www.accenture.com/child-welfare.
Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of The Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. On this week's podcast, we continue our series of guest interviews on the Indian Child Welfare Act and the upcoming case that could decide its fate, which is called Brackeen v. Haaland. Our past three episodes have focused on the law itself. We had Shannon Smith of the ICWA Law Center on to talk about active efforts. We had Tara Raynon from ICWA to discuss qualified expert witnesses. And then last week we had Chrissy Ross-Nemo of Cherokee Nation on to talk about the placement preferences when it comes to foster care and adoption. So today we're going to turn our attention to the case Brackeen v. Haaland that is going to be heard in oral arguments by the Supreme Court on this Wednesday, the 9th. And for that, we are bringing in Kate Fort, who is Director of Clinics at the Michigan State University College of Law. She's also one of the main contributors to the truly excellent Turtle Talk blog, along with the great Matthew Fletcher, and is also one of the lawyers representing tribes in this Brackeen case. So we talked to Fort about the constitutional questions that will potentially be discussed during the oral arguments on Wednesday, and the possible outcomes when the Supreme Court issues its ruling, which will probably be sometime in the summer. And we also got into a little bit about how Fort would blend provisions of the Indian Child Welfare Act, or ICWA, into other federal law and statute if that ever did become necessary. The Imprint also has a great breakdown of the Brackeen case up on our website, and just to help people understand the arguments on both sides, I will post a link to that story by Nancy Marie Spears in the show notes. I'll also link folks to a direct category page with all of our previous ICWA coverage in it, and then also a link to where you can listen to the oral arguments if you're interested in Brackeen v. Haaland on Wednesday. Last month marked 4 years since the initial ruling that got this Brackeen case started on its journey to the Supreme Court, when a district judge basically struck the entirety of ICWA down. Then the Fifth Circuit produced a very confusing 300-plus page decision that struck down some parts of ICWA, deadlocked on others, generally upheld the validity of the law, though. And that really dense decision kind of meant neither side would be satisfied and sort of set this on a almost certain path to the High Court, which we are finally at the end of on Wednesday. Finality will come to the legal battle on ICWA, at least for now, and then begins the likely month-long wait for the court's decision. Weirdly, this is the second consecutive big child welfare case that will be heard by the Supreme Court the day after a major election. The midterms obviously are tomorrow on Tuesday, if you're hearing this the day that this episode drops. The court heard Fulton v. Philadelphia, where faith-based discrimination by child welfare service providers was at issue on the day after the 2020 election. So you can imagine how much anybody really outside of the child welfare and legal community was aware of that case. All right, we'll do a few headlines and then get to Kate Fort, and we'll start with the newest release of foster care data from the federal government's Adoption and Foster Care Analysis and Reporting System, widely known as AFCARS. These reports basically lag a year behind, so the data we get in 2022 here is for the fiscal year 2021, and the point-in-time count of children in foster care that they use is from September 30th of 2021. So I'll link to our coverage of the new data and to the report itself if people want to look at it. But here's just some of the big takeaways. So first, the number of youth in foster care declined by 4% from 2020, and it dropped below the 400,000 mark for the first time in a decade. The last time there were less than 400,000 youth in foster care was 2012. This is in reference to the youth who are formally removed into care. As we've discussed on this podcast and in our running series on the Imprint, there's another set of youth who are moved from their homes to other homes by child welfare agencies. Usually it's to family or friends' homes in informal agreements that have come to be known as hidden foster care. So just put a pin in that. I want to come back to it in a second. Now, with this AFCARS report, it is certainly significant that the foster care total has substantially dropped again this year. That's 2 straight years, I believe, where the number has dropped 4% from the year before. And generally, the movements upward or downwards of the entire nation's foster care population, I think historically has been in the kind of 1% to 2% zone. So this is a 4% drop twice in a row. Everyone kind of knew that was coming in 2020. There was way less reporting and investigating in a year when social isolation measures, really forced schools to close and much of life just in general went virtual. That there was a substantial decline in 2021 could also have something to do with the pandemic. It certainly was just as virulent, COVID-19, in 2021. And there were plenty of courts that had not yet caught up on case backlogs from the previous year, but there was way, way less social isolation. So it's reasonable to expect that the front end of the system in 2021 was closer to normal business, certainly than it was the year before. So it is, to me, significant that this is now a second year where the number of youth in foster care has dropped. It tells me that it's probably very rooted in the pandemic and its kind of external effects, but not entirely. The trends on entry and exit also mirrored 2020. So entries into foster care were down by, I think, about 5%, but exits from the system went down from 224,000 or so to 215,000. So about a 4% decrease in exits. So this is the second year in a row where really entirely driven by a decline in entries into foster care, the number of kids has gone down, despite the fact that the states, as a whole, have slowed down in their ability to exit youth from the system. We'll talk a little bit more about that in a second, too. January Contreras, who leads the Administration for Children and Families, or ACF, that is kind of the main child welfare agency within the Department of Health and Human Services, said in a statement that the administration is, quote, encouraged that less children are entering the foster care system and that the system is more focused on keeping children with families. ACF will keep working with our state, tribal, and territorial partners to promote preventive services, safe family reunification, kinship care, and the well-being of the overall family unit, end quote. Now, she doesn't really call it out by name in the statement, but the preventive services she speaks of emanate from the new federal funding for such services out of the Family First Prevention Services Act, which was passed in 2018, and amends the Title 4E entitlement, which is kind of the main conduit of child welfare funds in general from the federal government to the states, which has largely in the past been used only for foster care and adoption. Now states are able to kind of hook into that Title 4E entitlement to pay for preventive services, things that are aimed at preventing foster care, not preventing involvement at all, but preventing the use of foster care in some child welfare cases. And it's limited to just approved services from a clearinghouse, and those services are largely rooted in either parenting help, substance abuse treatment, and mental health interventions. But most states had only just been approved to tap into that funding for the prevention services in 2021, and really lots still had not been approved. So, in my opinion, it's kind of unlikely that the Family First services had a big impact on this reporting year and what it says. So, I'm not sure that the Family First Act itself had this huge, effect on lowering the number of kids who were entering foster care. It doesn't mean that there weren't some states that had significantly more investment in prevention services in general, and some of them certainly could have done that while using the Family First funds that they had been approved for. But I'm not sure that enough states had been tapping into that money for long enough for that to be a major effect on this. There is some indication, though, that kinship caregivers have played a role in the post-pandemic trends, some of which is captured in this report and in one way that might not be. So kind of working backwards here, let's compare exits from foster care in the new report to 2019, which is the year, obviously, before the world went crazy. Youth exiting to live with relatives stayed about the same, but exits to guardianship went up a percentage point from 11% in 2019 to 12%. And this is an option that was bolstered with federal financial support back in 2008 by the Fostering Connections Act, sort of as a way for kin and family friends to take permanent custody of a child without the formality and the emotional baggage that goes with adopting, the child of a relative or a person who you are friends with. Within foster care, the 2021 report has 35% of kids in foster care living with relatives, and that's a full 3 percentage points higher than in 2019, which is real. It tells you that the formal foster care system is relying more on kin, and that presumably as formally approved or even as licensed caregivers. So they are being supported by the systems on par or at least close to non-relatives. Now, with entries into foster care, here is where there might be a kinship factor that would not show up on this AFCARS report. We mentioned hidden foster care earlier. That's the practice, again, of kind of shifting physical custody but not legal custody of a child, by way of CPS action, usually to the homes of kinship or fictive kin. It is not likely to show up in the official foster care data that the states report because no judge has ever really had to sign off on these removals. It's done as diversion, usually with a safety plan in place that is kind of agreed to between, the family, the kin, and the child welfare agency, but not a judge. So it is possible that at least to some extent, this continuing decline of entries into foster care that we know is attributable to a greater use of the foster care we don't know about. And there is some logic to the idea that in a pretty stressful work environment where the logistics of investigations and formal removals became more difficult, and many states had plenty of challenges keeping workers on the job in tandem with that the quicker and less administrative task of kind of just shifting kids to relatives with a safety plan became more attractive and was used more than usual. This is not in and of itself a bad thing. It's just that there is less guarantee of material support to those caregivers when they're not becoming formal foster parents. And there's almost no guarantee that the children involved will have, eyes on them from caseworkers like they would in formal foster care. But that is one factor, and probably not the only one. Here's another. Thanks in part to pandemic-era benefits like the child tax credit and increases in the earned income tax credit, the percentage of children living in poverty in America basically got cut in half over a 2-year period. I think it was about 11% in 2019, down to around 5%, a little bit above that now. And with more economic stability in houses with children, it's very plausible that there were simply less instances that could be construed correctly or incorrectly as neglectful behavior by parents or abusive. Just a few other things that jumped out to us, and we might revisit this once we've had more of a chance to kind of dive in here. In my opinion, one data point in AFCARS that really hasn't been talked about enough is the exits to reunification. What share of youth exiting foster care are going back home to their parent or caregiver that they were separated from? When you take a 5-year view and go back to the AFCARS report from 2016, more than half of exits back then were back home, 51%. And there was never an AFCARS report before that where the reunifications were under 50%. So all the way through 2016 and even a little bit beyond, there were always more than half of the youth exiting foster care going back home. Now it is pretty much entrenched in this 47 to 48% range, and in 2021 it was 47%. Add to that, the length of time that children stay in foster care is also up. The average time in foster care is up 2 full months from before the pandemic. It's now at 21.7 months. It was 19.7 months in 2019, and the percentage of youth who stay 3 or more years went from 15% in 2016 down to 14% in 2019, and now it's at 18%. So put together, it's to me a little bit of a cause for concern. You have less kids in general exiting foster care. You have less kids who are exiting foster care going back home via reunification. And then in general, they're staying in foster care longer. And also for youth who are adopted from foster care, the number of kids who wait more than a year after their parents have their rights terminated is also pretty big. It was 33% of youth waited a year or more in 2019. That's up to 40% now. And actually, that part seems very connected to the pandemic, I would suspect, because the adoption finalization process was definitely one of the things that slowed down or got put on hold during 2020 as most courts went to like only hearing emergency proceedings. Things like adoption were backburnered as the focus became really just decisions on whether they needed to remove a child into foster care. One last trend to note that really jumped out, seems to be a real positive one here on the 5-year range, is that the number of youth entering foster care because of a child behavior problem, so not due to abuse or neglect of a parent, a behavioral problem by the child, is way down. The percent of entries due to child behavior went from 11% in 2016 down to 7% in 2021. But it's really, when you look at this in terms of real numbers, it's staggering. It went from 29,000 children entering foster care due to a behavioral problem in 2016 down to just 15,000 in 2021. So that's a 47% drop. And to be honest, I would have guessed the opposite trend. We've talked about the children without placement crisis in Texas before on the podcast. That was fueled in part by the state lacking options for older youth who had entered the system as a result of behavioral challenges of their own. Ohio had to get a whole waiver to rejigger its Medicaid mental health array because the state basically conceded that it was advising parents who could not handle youth behavior to seek help by relinquishing them into foster care. And, that is per reporting from the New York Times, what happened in the case of Micaiah Bryant, who was an Ohio foster youth who was killed by police during an altercation outside of her foster home. So as mentioned, we may revisit with more on the new data soon, and the imprint will be soon coming out with its own annually collected data from states. We're hoping to have a solid projection on the number of youth in foster care in this calendar year, so 2022 numbers for you from that. Texas has sought to wall off access to gender-affirming care for minors through its dependency code, calling the provision of such services or its condonement by parents to be abuse. Alabama and Arkansas have both passed laws to criminalize such medicine and procedures, though both are facing legal challenges on that front now. And now Florida has banned these services for minors through the state's medical bureaucracy. The Florida Board of Medicine and the State Board of Osteopathic Medicine voted jointly to finalize rules that would ban gender-affirming healthcare for minors. This will take effect soon, and it was sought directly by Governor Ron DeSantis. The pretext for this has been in the works for a while. We talked about the moves that DeSantis was making on this about months ago on the podcast, so there's really no question that the timing of this vote was optimized, in DeSantis' view at least, for his upcoming re-election vote, which is tomorrow. Last piece of news here. On last week's podcast, we talked about the beginning of the shift of some Louisiana youth offenders into a temporary facility on the grounds of Angola, which is America's largest maximum security prison, which the government there deemed necessary because of security problems at a youth facility near New Orleans. Oddly, the youth that were ended up being sent to Angola were not from that New Orleans facility. They came from Acadiana and Swanson, which are two other fairly large youth juvenile justice facilities there in the state. And now another juvenile justice facility in the state has come under fire after a massive investigation led by the New York Times and the Grad School of Journalism at the University of California, Berkeley. The investigation found that in 2019 and 2020 at the Ware Youth Center in Coushatta, Louisiana, there were 64 suicide attempts. Additionally, 91 youth since 2019, it's about 5% of all the kids that were at Ware, attempted to escape. Ware holds male youths, but it's also a primary referral for girls around the state who have been ordered into secure care. And that is really the tip of the iceberg of what is reported here. The story, which uses interviews with mostly female former wards, paints a picture of a facility that was started as a local solution to, local juvenile justice needs that evolved into a big source of employment in a pretty remote area. And far from the gaze of most people, sexual predators and just poorly trained personnel were allowed to victimize kids with little serious inquiry or investigation by local law enforcement. You've got girls who didn't know each other in these interviews accusing the same staff of sexual assaults. Attorneys and supervisors are quoted in this story being brazenly dismissive of the interviewed youth in the story. And the piece ends with a well-verified account of one girl attempting suicide where the first guard on the scene filmed it instead of trying to stop her or help her. Governor John Bell Edwards has already launched inquiries into the article's findings, and I think it's a safe bet that you're going to see girls pulled out of there this week if it hasn't happened by the time you hear this. There's a part of me that wonders how long leadership has known this story was coming, though, and whether it and the likely need to relocate a lot of youth played into this new temporary release valve they created in Angola. I'm quite sure that the folks at the Department of Justice's Civil Rights Division are now aware and have taken notice of what's going on and what's been reported by the Times here. The state's juvenile justice facilities, and I should note that this Ware Youth Center was actually not a state-run facility, it was locally run, but the state's juvenile justice facilities came under federal oversight in 2000. They've since been released following decades of reforms. But now there's these dark details from the Ware Center that you've got youth staying in a former death row building at an adult prison that has also had its ton of its own problems over the years. None of this is good. All right, when we come back, our interview with Kate Fort about the Brackeen v. Haaland case and the future of the Indian Child Welfare Act.
Are you a professional in the field of child welfare, juvenile justice, or other family and youth services? Subscribe today to Youth Services Insider, the imprint's exclusive section on all the insider news you need to stay in the know. Funding opportunities, major federal and state policy shifts, interviews with key leaders in the field. It's all available only for our Youth Services Insider subscribers. Sign up for a monthly or yearly subscription today by visiting imprintnews.org/subscribe. Our podcast listeners get 10% off their subscription by entering the promo code PODCAST10. That's imprintnews.org/subscribe and get 10% off your subscription by entering the promo code PODCAST10 today.
We are joined today by Kate Fort, Director of Clinics, including the Indian Law Clinic at the Michigan State University College of Law. We've done a few episodes here breaking down some of the major provisions at the center of the Indian Child Welfare Act, and now Kate is going to help us break down what you need to know about Brackeen v. Haaland, which is the case the Supreme Court will hear on November 9th with massive stakes for ICWA. Kate, thanks for joining us on the Imprint Weekly Podcast.
Thanks for having me. I'm happy to be here.
Usual rules apply. They got to get to know you a little bit off the top here, Kate. So you got to give me one or more of the following favorites: TV, movie, book, musical group, or sports team. What do you got, Kate Fort?
Well, part of the problem is I have so many books and movies and TV that it's really hard to pick one favorite. So I'm going to just let you know, and getting to know me, that I really enjoy all of those things, all pop culture. I'll mail about it. But I am from Michigan. I grew up in Michigan. I'm back in Michigan. So my favorite sport teams are the Michigan State University Spartans, my beleaguered Detroit Lions, the Tigers, and of course the Red Wings. So
Kate and I are both current Michiganders. Her much longer than me, so I've inherited these teams, and you just can't help but pull for them. I don't know. I want them to do well. You know,
you just always want them to do well, and it's always a very the Lions in particular manage each week to find ways to be predictably bad. So
absolutely. Well, go green, go white. Okay.
Yeah, thank you.
So our goal today is to help listeners understand kind of two fundamental things about this case. First, the arguments being made about the constitutionality of the Indian Child Welfare Act and the counter arguments pushing back on them. And then second, what are the likeliest outcomes of this case, which we will probably not really find out probably till like spring, right? Something like that, maybe even summer.
Yeah.
So let's start with a challenge to ICWA under the Equal Protection Clause of the 14th Amendment. So Kate, can you explain that clause basically and why the plaintiffs in this case, Texas and the 3 adoptive families involved, are arguing that ICWA violates that clause in the amendment?
Yeah, so there's equal protection clauses in both the 5th and 14th Amendments, and essentially they state that no state can pass a law which denies anyone the due process of law or equal protection of the law. And sort of in layman's terms, this has been interpreted, this is understood to mean you can't pass laws that discriminate against people on the basis of race or other identified categories. And so the argument in this case has been that ICWA is a violation of equal protection because it legislates on behalf of Native children, or as the law defines them, an Indian child.
So in the interest of full transparency here, Kate is not like an independent voice in the middle of this. She is an attorney that is involved with this Brackeen case on the side of pushing for ICWA. So why, in your opinion, in your legal view, is this challenge on the 14th Amendment equal protection ground not correct?
Right. So this is sort of a foundational understanding of federal Indian law that can get really basic to people who practice in this area. So essentially, the understanding of how tribes and Native peoples relate to the federal government is that that's a political relationship, that we have federally recognized tribes, over 570 federally recognized tribes in the United States that have a political relationship with the United States. And then those tribes have the exclusive right and ability to determine their own citizenry. So they do that through their constitutions, ordinances, and statutes. And those are different for every tribe. So we have people who are identified perhaps as American Indian or Alaska Native racially, but are not actually eligible to be tribal citizens, that determination is a political one. For ICWA, the law defines an Indian child as a child who is a member of a tribe or is eligible for membership and the biological child of a member. By tying that so close to tribal citizenship, the law has, for the past 40 plus years, been understood to fall squarely under the political relationship, not a race-based relationship. And in the past, the Supreme Court has held that when Congress legislates on behalf of tribes and Native people, that they're acting under this political relationship. And in fact, if it was determined that this was a race-based relationship, that in fact all of Title 25 of the US Code, which is what governs tribes and Native peoples, would be unconstitutional under equal protection. So this is a real outlier argument that Texas is making that fundamentally really disagrees with about 200 years of constitutional law and Supreme Court holdings.
Right. And yeah, just to kind of like for a comparison in recent case law, right? Like the 14th Amendment does not necessarily preclude any race-based law from being valid here. It just basically has meant that if you have one, it is subject to a higher level of scrutiny. And so like for folks that may remember the Voting Rights Act,
Right.
which was passed in the 60s and was recently kind of peeled back by the Supreme Court, their assertion was when you apply strict scrutiny to this law, you know, back when it was passed, we needed it. And their view, which many disagree with, you know, at the time when they peeled it back, was that things have changed, right? And so like if this was the case with ICWA, right, if they actually were to, well, I don't want to skip too far ahead, you know, it would be subject to strict scrutiny if it was a race-based law, right? And that would be a whole other question to examine whether or not it stood up.
It survives strict scrutiny. I think it's really important. That's really important to note that, right, you have these different layers of review that the court brings to laws and to laws that they find do legislate on the basis of race. Yeah, you have this strict scrutiny, which can be very difficult to overcome. Basically, the law has to be narrowly tailored to serve this specific interest. When it comes to the lowest level of review, which is what the law falls under currently, it's a rational relationship, right? Is this rationally related to Congress's trust responsibility and goal to act on behalf of Native people and tribes?
Okay, so that was the first one. The next area of the Constitution involved in this case is the 10th Amendment, which states that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Now, there's something known as the anti-commandeering doctrine related to this amendment And that is what's come into play here. So, to the best of your ability, Kate, can you explain in layman's terms for us non-lawyers what anti-commandeering is and why challengers say ICWA runs against it?
Yeah, I actually just did a bunch of research on this for something I was looking up. And interestingly, not everyone believes that commandeering or anti-commandeering is from out of the 10th Amendment, which
Oh,
is really interesting. Like there are
plot
legal
twist.
scholars who fight about this. I had no
Mhm.
idea. It basically says that the idea in ICWA is that the 10th Amendment does mean that unless something is very specifically held to Congress, it belongs to the states. And so for it is true that for years there's this kind of old legal chestnut that all of family law is for the states, like that's reserved to the states, even though I think any of us who practice in the area understand how Congress uses the spending clause to in fact create reams of regulation about our child welfare
100% right.
laws, right? The spending clause. So the argument that Texas has been making is that Congress kind of don't want to. I'm gonna spoiler alert. Our next question is Congress doesn't have essentially enough power under Article 1 to be able to pass a law that preempts state laws in child welfare proceedings involving Native children, and that in fact what ICWA is a law that commandeers state agencies and state courts to enact a federal scheme, and that is prohibited. And I've been actually talking about this topic a lot because I thought that this was probably Texas's strongest argument, and I thought this was what they were going to talk about most in the briefs. They ended up not doing that. And so that this is a real question because the court has shown such interest in these commandeering cases, I'd say, increasingly since the court first created it essentially in the 80s, has really increased the number of these cases it's heard in the last 10 years. It sort of fits the narrative I think a lot of us recognize as the question between kind of states' rights and federal power and who has the right to pass these laws that govern these cases. It's really interesting in the legislative history. If you're talking about 10th Amendment, so the legislative history for ICWA is 1978. The House report that accompanies the bill was before the first commandeering decision by the Supreme Court. They address the 10th Amendment directly and say, leading into our next question, that the plenary power of Congress to pass laws on behalf of Indian tribes preempts any state law, and there are no 10th Amendment concerns.
Got it. Yeah, I think I was trying to think of an analogy for folks that are maybe more familiar with general child welfare policy, but think of, okay, there's a lot of debate and controversy around the Adoption and Safe Families Act now, which has a law that, on paper instructs states, you'll often hear described as requires states to have this timeline on which they terminate parental rights. But that is, to Kate's point, that is put down to the states as a proposition in exchange for money. No state has to do it. They could say, no thanks, keep your federal money, and we will do what we see fit with the end of cases where foster care is involved. That's on them, although we know that there's the money that
it's so much money. Yeah. The example I love to teach my students with is not related to child welfare at all, but is related to federal highway funds and why the United States has essentially a uniform minimum drinking age of 21. And it's because at some point Congress said, look, you don't have to change your drinking age, but if you want your federal highway dollars, you have to pass a law raising the minimum drinking age to 21. And one of the reasons why Louisiana's highways are so bad and so old is because they forewent federal highway dollars for a very long time before they finally capitulated and took the money.
So to bring this back to ICWA and these challenges that we're commandeering, I guess the difference between what we're talking about and ICWA is there's not necessarily money exchange per se. It's instructing states, this is something that we have in our, what Congress's view is, or has been, is this is something in our power to do. We have to do it. and you have to act accordingly because it's
Yeah, exactly. ICWA is not tied to the Social Security Act. And actually, I had just discovered this for an article I just submitted. During the 1977 hearings, the Department of it wasn't called HHS at the time, it was HEW, but they came, way back. They came to the Senate to testify about ICWA, and they said, hey, you guys should know we are moving this bill that creates a new section E of Title IV, and it's going to govern and really give proper standards to our child welfare proceedings in the states. We think actually we should put some of ICWA's provisions into this new section E. And the people who had been working on ICWA for a very long time were like, we would really prefer not, because we have a history of knowing what happens when we get lumped in with all the other groups, that none of our protections actually, they were so far down the road with ICWA, it would mean essentially starting over. But as someone today looking back, we're like, oh, if ICWA was in 4E, we would not be here on a 10th Amendment commandeering question. It's a really fascinating little history. So ICWA is passed before Title 4E of the Social Security Act is enacted 2 years after ICWA. So it's a really interesting timing, alternate universe question.
So I think we skipped by it, but like in kind of a one or two sentences, make your elevator pitch for the requirements of and the state's obligations under ICWA are not commandeering. They are not. What's that argument?
So the quickest argument will be our next discussion, which is if Congress has Article 1 power to pass a law, then that is a preemption. They are preempting existing state laws. They're not commandeering the states.
Okay.
The second is sort of an interesting one, which is to say, as part of the commandeering doctrine, the court has held that if a law spreads its burdens equally on private and public parties, so on the state or public parties, that it's not commandeering, and that or private parties. And we know that's the case because ICWA applies to private guardianships, it applies to step-parent adoptions, it applies to adoptions, it applies to third-party custody proceedings. So while it is true that the state, is the source of most removals and of most foster care, ICWA's application is not limited only to state courts. It also affects private parties. And then the sort of third argument is that what ICWA does is require state courts to follow the certain burdens of proof in order to do the thing. So you've had these episodes on active efforts and qualified expert witnesses and all these things. That's under 1912 of ICWA. And all of that says, for active efforts, for example, that they have to convince the court that active efforts happened, or that the court needs to make a finding supported by the testimony of a qualified expert witness that return of the child is likely to result in serious physical or emotional damage to the child to a clear and convincing standard, or a beyond a reasonable doubt standard. And so Congress can pass laws that courts have to enforce, right? The Supremacy Clause says that the U.S., the congressional laws are the law of the land, and that what you're not doing is commandeering agencies, but rather giving standards to state courts that they have to follow. And then the final argument, which I think is a very interesting one, a very strong one, is ICWA essentially creates substantive rights for parents in child welfare proceedings. ICWA has created a higher burden of proof, the right to active efforts, the tribes and parents' right to a qualified expert witness testimony, the right for children to be placed with their family and community and the placement preferences, and that those substantive rights are not commandeering state agencies to do something, but rather are a creation by Congress that the states have to enforce.
All right. So as Kate alluded to, we come to the third and final kind of component of the Constitution that is in the mix for this case, and that is the Indian Commerce Clause, Article 1. So when ICWA became law in the 1970s, Congress said it was done in accordance with congressional authority under the Indian Commerce Clause. So what is the Indian Commerce Clause, and what is the argument that this is, an improper use of the clause?
It's one of these really interesting things. I think for people who aren't constitutional lawyers, we act like these clauses are like these really big deals, and they're just these pieces of sentences, right? So the Commerce Clause states that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And so the Indian Commerce Clause is with the Indian tribes. That's the piece we're talking about. And I think it can be extremely confusing to understand that historically that clause by the framers is understood when we pass the Constitution. The goal was to centralize all interactions with the tribes, with the federal government, because at the time of the passing of the Constitution, states under the Articles of Confederation, states are doing their own back and forth with tribes, and it's going really badly. And the new nation is really at the mercy of the tribes that are here and their alliances. And so they were trying to figure out a way to centralize policy for the federal government. That is the Indian Commerce Clause. But we also know then there's a lot of great research on this. There are experts that are just looking at this one thing. Professor Oblonsky at Stanford filed an amicus brief just talking about the history of the Commerce Clause and what it means. I'm going to kind of skip that and talk more broadly about, we use the Indian Commerce Clause to stand for the proposition in many ways of the trust responsibility, which is the relationship, again, tied to that political relationship, the federal government to the Indian tribes. And that trust responsibility is grounded on the Indian Commerce Clause, the treaties clause, the treaties that were passed between the federal government and the tribes, the exchange essentially of tribal land for this country to extend in exchange for services and protection by the United States. And so that trust responsibility is a very broad and important and foundational responsibility that the United States has and owes to the Indian tribes in the United States. It's also understood to be extremely strong. It goes so far, the court has in past cases held that Congress has what we call plenary power over Indian tribes, which means exclusive, right? Congress has plenary power in the area of immigration, which means it's exclusively Congress's job to deal with immigration. And the court has held, much to, frankly, the detriment of tribes in the past, that Congress has plenary power to make any decision it wants regarding laws involving tribes. And in the past, those holdings have been deeply damaging to tribes. And there's sort of infamous cases in federal Indian law. There's Lone Wolf and Kagama, where tribes went to the court to try to seek relief from congressional decisions. And the court was like, yeah, this is not, this is Congress's responsibility. And so it's really interesting that we've moved to a place now where we understand where President Nixon declared, and we are still in the era, what we call the era of self-determination, which is Congress is supposed to use its power in order to protect tribes, to assist tribes in having tribes do their own self-governance, recognizing their sovereignty, ensuring they have the ability to run their own systems and essentially be left alone to figure out the solutions to their problems under that trust responsibility, and then empowering and tribes to be able to do that. And so we're in a very different policy era than we were when those initial plenary power cases came out. But it's really interesting that we've come now, to here where ICWA is tied explicitly and directly to the Commerce Clause, the trust responsibility, the political relationship. And now we have, Texas and these foster families wanting the court to say, oh, actually, Congress doesn't have plenary power to do this, good thing that tribes went to Congress and asked for repeatedly, and that the Commerce Clause means only that Congress can regulate literal commerce with tribes. And so this would be a real narrowing of the understanding of congressional power in this area if the court accepted Texas's argument.
It's that time of year where nonprofit journalism organizations are looking to maximize giving through the annual News Match campaign, and we are no exception. If you enjoy this podcast or the great work our reporters do at the Imprint and at Fostering Families Today, please consider making a donation. And if you do so this month or in December, during Newsmatch, your donation will get doubled. Fostering Media Connections is very lucky to have some terrific philanthropic supporters, advertisers, sponsors, subscribers, but we really cannot do it without donors like you who read our stuff, listen to our podcasts, and attend our online events. There are tons of really great nonprofit independent news outlets to support out there, and we hope you consider us one of them. To give today, it is easy. Visit imprintnews.org/donate. That's imprintnews.org/donate. I want to run a few possible outcomes by you, Kate, to see which you think are, likely or unlikely. Get your thoughts on them, and then I want to hear from you on ones you think I missed. Before we get to that, I think it's probably important to note what's happened in court leading up to this, so that we know what the outcomes were there. This thing starts, at least federally, in a district court in Texas, the region that covers Dallas, with a judge named Reed O'Connor, who basically just chucks ICWA entirely. He says the equal protection claim is right, that ICWA is race-based. He strikes it down on that. He says that the anti-commandeering arguments he agrees with those. So he strikes it down in a lot of different ways. And then it comes to the Fifth Circuit Court of Appeals, who reject his findings that ICWA is unconstitutional in the Equal Protection Clause sense, but does strike down active efforts, record keeping, which is kind of a minute tangential point to ICWA, and then the use of qualified expert witnesses. But the remainder of ICWA remains under the Fifth Circuit. So I guess I say all that to let's go through some of the possible outcomes here now that it's at the Supreme Court. So first one, to start off with probably the easiest to kind of envision, which was that ICWA is upheld in its entirety. There are certainly some conservative justices who in previous cases have indicated a willingness to cut back ICWA further, but then they are not joined by enough colleagues to change anything about ICWA. So that is a possibility. What do you think of that one? Unlikely?
That would be great. And I can't speculate too much since I am an attorney on the case and we are winning the case. But yeah, absolutely. That's the goal. 5 justices agree that ICWA is constitutional and perfectly reasonable exercise of congressional power. If that's the case, I would really hope to see like a reduction in the number of lawsuits. We have been seeing the way we have since 2013, essentially since Baby Girl, and then re-empowerment, reinvigoration of how are we going to fund and increase the capacity of tribal child welfare systems so we can continue to encourage, like I was saying before, tribal self-determination, tribal self-governance, and tribal sovereignty in this area.
Okay. I think it would be safe to, I don't want to put you in a weird spot here, but would you agree that the general mood and anticipation does not favor this outcome? I don't think I've met anybody whose feeling is like, I'm pretty sure they're going to just keep it as is.
I will say this. I think it means that in order to get 5 votes, we would definitely have to convince either Justice Comey Barrett or Chief Justice Roberts to agree that ICWA is fully constitutional. And you can decide how likely you feel that is based on your understanding of those justices. So
the second outcome I wanted to run by you. The court sticks to the findings of the most recent court and the provisions that were ruled unconstitutional in the Fifth Circuit, which were active efforts, record keeping, and the use of a qualified expert witness are struck down, but the remainder of ICWA remains. Now, I just say armchair layman, I kind of like Occam's razor tells me that's kind of like maybe the most likely possibility, only because I feel like it's the safest to focus on what the lower court focused on, but I may be way off there. What do you think?
So what I will say is that factually, what I can say about the Fifth Circuit decision is that there were a number of provisions that were decided by a split vote of 8-8. And so I think that if the court said, hey, they're following that lead, that would be essentially a decision about anti-commandeering, that the law commandeers the states. And we would have to see how far the court would go with all the different provisions of ICWA whether they are in fact commandeering the states. But that would essentially be, the reasoning would be a commandeering reasoning in that scenario.
Okay. Third option, the entire law is struck down on the basis of the Equal Protection Clause, meaning that the court has found ICWA to be a race-based law that, I guess if they apply strict scrutiny in the decision, doesn't pass that, and they've struck it down. Now, this is the one with the most far-reaching consequences beyond this law, right?
Yeah, I would say that if we had a holding that was that, what I would say radical, that would be a real fundamental reordering of all of federal Indian law. And so from the perspective of, it would be, I find it virtually impossible to think about in the context of just ICWA, because it would be discussing, I can't stress to the audience enough that, especially if you don't work in this area, how large of a sort of federal bureaucracy there is that exists surrounding tribes and, the Department of the Interior, the Bureau of Indian Affairs, the number of laws in Title 25, Title 18, criminal jurisdiction, civil jurisdiction, ways in which tribal governments operate every single day as a government to their people. We would be talking about sort of potentially a real upending of a system that has essentially been established since our founding. So it's really hard to me to even kind of think about that outcome. And I am sure that any outcome that's based on equal protection would have to be a fairly narrowly tailored to ICWA, and that we would, people would have to look at it and think about it after the decision came out.
How would that play out? I mean, so if it actually went this way, like, does it just in and of itself, like the building crumbles then, or does this just open up like a million little challenges to Indian law that eventually would take it all?
Yeah, I can't really speculate without seeing what the language would be.
Sure.
You could imagine it would really depend on how the court wrote the opinion if it went on equal protection.
So then the fourth option, I guess I'm kind of doing a 4A and B here, is that the entire law is struck down due to arguments around anti-commandeering, the Indian Commerce Clause, or some combination of both.
Yeah, I think that's obviously it's a possibility given the arguments that are out there. I think the positive outcome to remember from something like that is that any state law that's in existence, any state ICWA, would not fall in that scenario. States can't commandeer themselves. They can pass laws and govern themselves. And states don't need congressional Article 1 power to pass their own state ICWA laws. Again, it's very hard to say. You'd have to see the language. You'd have to see the breadth of the language or how narrow the language is. But there are ways in which the ICWA's practice could absolutely continue in a scenario like that. It may have some broader effects on other laws that Congress passes, and that would be for another day to speculate on. But again, like I said, in 77, Congress had the ability to put ICWA into Title 4E. Congress still has the ability to put, no matter what the outcome of the case is, right? Like, even if we win, Congress has the ability to put ICWA's protections into Title 4E. Congress has the ability to address, use the spending clause if it wants to address some of these concerns. States have the ability to pass their own state ICWA laws. The Uniform Law Commission study committee started to determine if it makes sense to move forward with drafting a model or uniform state ICWA law. And I think I'm going to pivot on you. I really like state ICWA laws for a lot of reasons. I love the protections, obviously, that ICWA provides federally. ICWA is a 14-page law that was passed more than 40 years ago. Our understanding of child welfare has really changed in that time, and state practices have changed. And some of the biggest difficulties that state judges have in enforcing ICWA is figuring out how it applies in their state systems and when it applies. And so when you have a state ICWA law, if you build those protections directly into your state law, you can answer those questions for judges, right? Like, you need to put this standard, you need to have this at your shelter care hearing. You need to make a finding about active efforts at adjudication. Like, you can be explicit about those things in state ICWA laws that national laws can be really hard to do. And honestly, putting it into 4E would do a very similar thing, right? It would say states have to pass laws essentially that incorporate these protections, and then the state laws would incorporate those protections. So I don't think it's a bad thing to have ICWA's protections incorporated into state laws. I actually have come full circle and think it's a really beneficial thing and has helped us in the states where I practice that have state ICWA laws. We tend to have better educated judges, better educated attorneys on the issue, and more buy-in and compliance into the protections.
When you say full circle, were you a little wary of having?
I was. So we started in Michigan working on essentially a judicial, kind of a bench book. They didn't call it a bench book. They called it a guidebook, which took all of Michigan's case law on ICWA and kind of distilled it for judges and said, here's how ICWA works. And as a result of that, which was done in collaboration with all 12 tribes in the state of Michigan, as a result of that, our court improvement program used additional funds, used additional funds to bring a very large group together, representatives from all the tribes, representatives from probate court, district court, the police, state police, anyone who has any hand in child welfare at all, to come together and draft a state ICWA law, the Michigan Indian Family Preservation Act. And I was a part of that process from the very beginning. I was somewhat skeptical, just because we have ICWA. Why do we need to create another level of authority? And we got that and the tribes wanted it. So, in my clinic, I represent tribal governments. I act at their direction. It's not my opinion. But just personally, I was like, I don't know, man. I'm not sure I need this. We passed it in 2013. It's made a huge difference. It just has. We have fewer appeals. The appeals that we have had have been easier to settle when it comes to sort of transfer to tribal court or placement preferences. The same arguments don't apply because we tightened up certain good cause exceptions. There's some confusing parts I would probably look at again in the guardianship area, but as a whole, I don't know if you know this, but in Michigan, we don't have to have continuing legal education credits. So there's no real way to force training, but in the trainings that we do have, the state different groups have been really great at including MIFPA. So I've spoken to the state appellate attorneys. I've spoken to the judicial conferences they have. The state court administrator's office regularly offers MIFPA trainings. It just becomes ingrained in state practice and state law in a way that ICWA never really did. And I don't know that that's inherently good or bad, but I do think that for the what do you want to affect? You want to affect outcome changes. I think it makes a really big difference to have a state ICWA law.
What do you say, going back to the federal for a minute?
Yeah.
Take ICWA and put it in 4E. What generally, how do you think that would work? Essentially taking all of the provisions of ICWA and saying, adhering to this is, you can't get any of your 4E money if you're not complying with this specific list of provisions.
The law. So there's a couple different ways that I envision that could happen, and it would sort of depend on what happens in the court. But so the kind of easiest, most straightforward, if we were talking about this outside of assuming Brackeen doesn't exist, right? We're just how are we talking about this in terms of 4E? Mm-hmm. You could add an element to, 671 to elements of a state plan that say, number, what is it? I have my 4E right here, just sitting by my desk. Yeah. You could just add it as what is it? Number 38, 37 is in your state plan. States shall comply with the Indian Child Welfare Act, right? And just cite to the laws. That's a fairly straightforward one. The sort of more interesting question that if we had kind of a perfect world where we could spend time thinking about things is, there's a lot of conversations about should active efforts be available to all children and not just Native children. And if it is a gold standard, which it is, should that be incorporated? And so do you take the active efforts definition from the federal regulations and incorporate that as a replacement for reasonable efforts and give judges an actual checklist of things that the agency should be doing for every single child? So are there ways to do that? Are there ways to incorporate the parts of it that would be beneficial for all children while also incorporating the pieces that are really specific for Native children, notice to their tribes, the ensuring that there is a witness that's there to say, yeah, no, we are looking at this and this doesn't have to do with a cultural misunderstanding, but actually the child should be removed here, which is essentially your qualified expert witness. And do you incorporate that essentially as its own section of 4E that you add it at the end, right? Like we keep adding, you mentioned AFSPA, and we had Families First that was added in. Do you add in like a 677B? That's the ICWA provisions that are required as part of 4E.
Yeah, I could see where maybe you get a mix of things that just become part of general code. Like, okay,
right.
It's like now we're really just kind of hypothesizing here, but
yeah,
you could do active efforts for everybody, right? And then you could say there's a section of 4E on tribal notification and intervention. And then I think the one where it would get politically divisive or debated would be how you would incorporate the placement preferences in ICWA, because that's where you're saying we're going to make a different expectation of states and how they would handle one case versus another.
Except, did you see the batch of laws that came through here in Michigan just now that about there was like 12 bills that came through, and one of them is finally like, actually you really do need to put kids with their relations, which has been a recommendation requirement of 4E for a while now, that you're like supposed to be investigating kin relationships, and it's been this kind of uphill battle. The question of sort of, I agree with you that could be political, but I could also think of ways in which we're talking about, okay, we're talking about extended family, which is the first placement preference, which is true right now under federal law for all children, not just Native children. The second preference is a home that is approved, licensed, or specified by the Indian child's tribe. And so the tribe is a party to the case. I could personally imagine pilot projects where we're talking about, okay, who is this child's community? So we keep the Indian child's tribe. We do keep that for Native children, but all children have some kind of community that they are a part of. And we need to be talking about and now we're really into sort of radical reformation that I'm far more interested in, but how are we engaging the child's community and broader support system to approve of a place where that child goes? Maybe it's a community that includes teachers and neighbors and is like, you know what, this kid, the thing this kid really loves is this baseball team. And it would absolutely cause far more trauma if this kid is put in a home too far away for him to be a part of this baseball team. Or pick your thing, right? Like this child is an active participant in this theater or is really close to this teacher. There are all things that kiddos have that we do not account for when they're pulled from their home. And there are ways in which the Indian child welfare is based on tribal sovereignty and that government to government relationship. And the reason why tribes are involved is because the tribes have a responsibility to the children that are their citizens. But in the placement preferences, honestly, that the Indian child's tribe has a role in that second is essentially saying who the Indian child's community should be helping to make that decision about where that child should be placed. And a lot of times that means they're placed somewhere close to their parents so they can reunify. It doesn't mean that it's an Indian home. It just means it's a home that the tribe agrees is appropriate for the placement of this child. I don't know. I get going really fast when I start thinking about like, how would I actually
do it all?
Truly reform some of these systems? And, it would be difficult. Listen, doing anything like that to 4E would be a massive political lift. There's huge group. It's way bigger than ICWA, right? 4E has a number of groups that are intimately interested and involved in any level of change. It would be a big lift. But I think there are ways in which we can look at what ICWA has provided and continues to provide and think about how we can use that to change a system that I think we all agree is pretty fundamentally broken.
There is a kind of a bill on one side of the house right now. We've been talking about 4E, which is the much larger entitlement, where most
Right.
of the federal dollars flow to states. But I don't know if you noticed that the Strengthening Tribal Families Act of 2022 got dropped, and this sort of ties ICWA compliance to Title 4B, which is a little bit of a smaller program. It's like, I think it's like $600 million a year. And I guess there's been some speculation like, okay, now if this was to pass and now all of a sudden ICWA compliance is tied to some federal money, does that address or mitigate any anti-commandeering concern? I just don't know. I don't know enough about anti-commandeering to know. It seems like saying comply or you'll lose money is not enough. Like, it would actually have to be tied to money to do it, to get around the anti-commandeering, if you believe that was a true criticism, right? So anyway, I'm rambling.
No. I know the bill you speak
Yeah.
of. There are some really interesting holdings in the area of spending clause power, and we would get kind of too far in the weeds, but that have to do with whether you can fundamentally change a program that's already in existence.
Mm-hmm.
There's been some litigations, Supreme Court cases on that. I think it's NFIB, but I would have to go back and look, that discusses these issues. The last time I saw the language for that bill, I didn't think it changed the language that already exists. I mean, 4B already has language in it about ICWA, consulting with tribes about ICWA compliance. It wasn't clear to me that the language in this new bill was so different and so distinct that you would end up with a different legal argument than what we already have. Also, the briefing is done. So
Oh yeah,
like,
that
the
would
court
be the
could
weirdest
see
thing,
the law,
right?
but
Yeah.
I mean,
Yeah.
it's done. We've long since passed the time when any kind of legislative fix would have made a difference to the case. So, and like you said, it's in the House. There's a lot going on this month between, that we'll see what happens with that bill. But yeah, I don't know if the language in the way it's been introduced would actually address any of the sort of legal commandeering issues.
Yeah, well, to your point, I was wondering that myself, whether or not they're essentially, the justices, I mean, kind of, once they hear the oral arguments, they just wall off anything in between them and then in the decision, or
I mean, I assume clerks research and can find it.
yeah.
The question is, they don't have any. It would be a sua sponte analysis of assuming it became law. I mean, that's the other thing, if it had the power to, I don't want to speculate too much, but if it's just a bill in there's a million bills in Congress,
Of course,
so
right.
They don't consider all the bills in Congress when they're making decisions. So,
of course. Okay, so going back, I went through 4 outcomes here. ICWA being held up entirely. Court kind of follows the Fifth Circuit's decision. The entire law is struck down as race-based and equal protection. The entire law is struck down around anti-commandeering, Commerce Clause, or both. Are there others that you think listeners should know? Are there other outcomes that are kind of on your board as, strong possibilities or, possible outcomes?
I think what I'll say in response to that is that the court accepted 7 questions for review. There is a distinct possibility that whatever decision comes down, when it comes down, like you said, it will have to be before the end of June 2023, that it very well could be very long and confusing, and that I would advise listeners to wait till people get a chance to sort of read it and digest it before making any really broad statements about its holding. So I guess you can kind of read into what I think might happen based on my advice here, which is, I would just say, give us all time to read it through. And, last time, let me put it this way. Last time we got adoptive couple versus baby girl, and it was a loss. It was a loss for ICWA and a loss for Dustin, the father in that case, whose daughter was taken from him. But ultimately, the interpretation of it and the writing about it and the understanding of it really ended up narrowing that holding so tightly that we don't engage with that law much outside of situations that involve putative fathers in Montana. That's really where right now, if you want to see where's baby girl getting cited, it's in Montana for dads who aren't, have an
Custodial
established,
laws,
dads who have an established paternity, right?
Right. Yeah.
That's where we see it. And when it came down, I think there was a possibility that it would have been very like, oh, the sky is falling. And instead it was like, all right, let's take a look at this. Let's see what it says. As we've talked about, I think before we came on, the court doesn't know child welfare very well. It's entirely possible that however it writes it, it may end up not creating confusion. And so I think it's important that when we get that decision, we take a beat, take a look at it, see what it actually says, and go from there.
And
On the other
one good
hand,
thing, it couldn't be more confusing than the Fifth Circuit's ruling, which was an staggering 300 and I want to say 24 pages or something like that. I'd never seen anything like that.
Nope.
So it can't be less clear.
I and if it is something like that, then again, I think one of the most interesting parts about that Fifth Circuit decision, and frankly, since the crazy decision in the Northern District of Texas, I've been practicing ICWA appellate practice this whole time. So on one hand, I'm representing the tribes in this federal case. On the other hand, I have tribal clients all over the country that I represent on appeals. States and tribes have been operating like everything is normal. There's hardly any case. I have not found a case or been involved in a case or read a decision that's like, oh, well, the Fifth Circuit said this might be unconstitutional, or the Northern District of Texas said this is, if anything, there are footnotes that are like, yeah, we're aware of this case. Good deal. Moving on, and so it'll be really interesting just to see exactly how any decision from the court ends up actually changing practice on the ground.
Well, listeners are hearing this interview on Monday the 7th. Next day is going to be the, I think, 44th anniversary of ICWA, and then the day after that will be oral arguments. So I will drop a link in the show notes to where you can go to hear the oral arguments. I will drop a whole bunch of stuff into the show notes, our previous coverage, some of the stuff that Kate has done on this case, and a link to the extremely useful Turtle Talk, which I forgot to mention at the top. But Kate Ford is one of, and Matthew Fletcher do an amazing job with others as well. So Kate Ford, Michigan State University College of Law, thank you for joining us on the Imprint Weekly Podcast.
Thanks for having me. It's great to be here.
Thanks to Kate Ford of Michigan State University for joining us today, and thanks to Accenture for sponsoring this episode. The Imprint Weekly Podcast is a production of Fostering Media Connections, a California-based nonprofit that publishes the Imprint, Fostering Families Today, and operates the Youth Voice program. This podcast is produced and mixed by Christine Anjoko, with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we'd really appreciate if you would support our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, it is super easy. Just visit imprintnews.org/donate. You can follow the Imprint on Twitter and Facebook by searching the handle @theimprintnews, and visit us on the web at imprintnews.org. And you can always reach us over email at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.